still be able to travel using a cycle, but that would lead to a new innovation of a new type of cycle. There are cycles where people do not want to sit, they want to stand, they want to walk. So when someone is walking on the cycle, so there is a sort of treadmill which is fixed on a cycle, and they want to go to work while not paddling, while not sitting on a cycle, on a bicycle. So they can walk, and with that, the energy from the treadmill will be transferred to the wheels and the cycle will start moving. Even if we try to remove the wheels from the cycle and you have the paddling there, so it can be used as a fitness equipment in gyms. So what I'm trying to say here is that by eliminating certain parts of a conventional product, still you can innovate. Of course, it will be in different sectors, but again, innovation is there. So we also need to think about elimination, where we are able to remove unnecessary and redundant or less valuable features from a product or a service or a process and
Sir, your audio is not, we are not able to hear you. Presentation is moving, but audio is not audible. You are on mute.
Am
Yeah,
I
it's,
audible?
yes, sir, you are audible.
Am I audible?
Yes, you are audible, sir.
Yeah, yeah. Actually, there was some problem with my laptop here. So yeah, that's fine. Okay. So we were talking about the elimination. And after that, if we see the reconfiguration, so here what we are doing, we're trying to alter some known structures or arrangement of the existing component and processes or systems to achieve better performance and efficiency. So if I want to give an example, so when we try to shift from the traditional retail stores to e-commerce platforms, so nowadays we have this wholesale market, we have, and where we go and buy things like supermarkets, and the irritating part of that is when you are standing in a queue. So instead of that, if we have a kiosk, so that would save manpower, that would make the process much more faster. So here we are trying to reconfigure the shopping experience, making buying more convenient for the customers. If we look at the substitution part, so substitution is one of the mechanics of innovation where it involves replacement of one component or components, material or process that would improve the performance and also cost effective. So here the goal is to enhance the innovation by using superior alternatives. So we have all seen light bulbs earlier used with the carbon filaments, now which were later substituted with the tungsten filaments. And that's also very soothing for the eyes. For amplification, if we see, which is referring to strengthening and enhancing a particular aspect of a product or services. So we can take example of noise cancelling technologies in the headphones, which would amplify the user's listening experience by eliminating the external distractions. So here is an example of combination where we can combine smartwatch, the functions of the smartwatch, where we, in old days, we have traditional watches. So here we can get notifications on fitness, tracking, and other apps. So you are trying to combine smartwatch with the phone. Now, for adaptation, this is a classic example of a Velcro. Now, which is adapted for tiny hooks found in the buttocks. Now, which will help us to stuck clothing into a versatile fastening system. Now, when we are trying to reframe, now reframing is when we are trying to reframe a business. Say, for example, Uber. Uber is not owning any cars, but here they have been able to reframe this transportation from the ownership of cars or dispatching to a platform for sharing personal rides. So this also opened a new market by looking at the available resources differently. Now, if we also give an example for reframing like Oyo, they don't own any hotels, or say booking.com. So here they have tried to reframe their business thoughts. And this is the last one, right? Yeah, so about experimentation, we can give an example of Google's early beta launches, which allow users to experiment with new features where we would have a feedback informing further developments and improvement before a full-scale rollouts. Yeah. So in the stages of innovation, it starts from the conception stage, then we have research and development, and after R&D, we would go for the production and the commercialization. So in the stages of innovation, the first three stages would be the basic scientific knowledge. Then we have our ideas for new process and the blueprints. And we would try to make the initial prototype of the products. Now, when we are talking about the innovators, so it can be an individual or a multinational companies or corporations. And then we have the institutes, universities, and the startup companies. And all of them can collaborate with each other based on the particular domain of technology. Skip this one. So the main thing which we should keep in our mind when we are talking about innovation is that for any particular product, when we are trying to innovate, we should know how to manage it internally. So for that, we should have some awareness of how IP management can be improved within a company. One is that greater information resources. So we should provide the employees with resources for greater information. Then there should be set guidelines in the company for valuing and IP management. And there can be some target training courses available to the upper management of the company. So this is a very concerted approach, you can say, where you have the information packets which can be communicated to the targeted employees. Then you can have internal guidelines on how you should protect the IP, what can be the value, what can be the strategies, and also identify and develop and implement a particular targeted product. Skip. Patents. Patents, as we all know, that's a territorial right for 20 years. So it allows publication of research points, leads to further innovation. And of course, patent rights can be transferred. So these are some procedural aspects of patents. I'm not going into this in depth. So we have to submit it with the patent office in a particular jurisdiction where we want to protect. Of course, in a patent specification, we need to see that what others have done, what is the need of that particular technology, and what we are trying to do and we are trying to protect. Next. Yeah, so when we are talking about the management of intellectual property, so we have to look into the commercialization of the R&D and the revenue which we can get from licensing. And if we are able to permit exclusion of the competitors and then we can reassure the investors. And the third one would be to secure our freedom to operate in the international markets. So this is basically about the IP management tool, where we would be able to generate and capture value for a particular intellectual property, looking at the market dynamics and the global economic trend. And we should also be able to assess the quality and scope of our IP document, which we have already protected. And then we should define the target products in the market and try to evaluate our IP with respect to those target products so that we can secure new revenue system. So the main thing is the IP management. In the IP management is the life cycle of a particular technology. So you can see in the graph that when a technology is emerging, so after a certain time, it will reach its standard, and then it will go to the maturity. So here what we are trying to say, that timing of our innovation is very important. Now, for example, if we take smartphones, and let's think that the smartphone is not existing today. If someone is coming with a smartphone after 20 years, so what will happen? So no one will be interested in that smartphone. So to get a particular group of customers to conquer a particular market, rather to conquer a particular business, we should know exactly when we have to launch a product, what is the correct time to launch a product, and when such product will reach its maturity. Because after that, no one will be interested with that product. So we have to withdraw that product also. Now, for example, if we take iPhones have different models over the years. So now it will be iPhone 16, 16 Pro, 16 Pro Plus. Then why iPhone went on innovating new products with new product features? And why someone is not using the first iPhone which was launched? So there was a market need. There was a market expectation. So this we have to understand. So this is going into the core of IP management. So here we don't need to elaborate on this. We have already discussed about the claims. So open innovation. So here we need to understand that when we are talking about the inflows and the outflows of knowledge, where we will go for accelerated internal innovation, and we will try to expand the markets for external use of the innovation. So when we talk about open innovation, it's about the knowledge which is widely diffused in the society. So we would not start from the scratch. So there is a basis based on which we will start innovating, and we will reach a particular product which is desired. So this is again for the open innovation. So here we would try to understand the internal and the external venture handling, then the new product which we are going to launch in the market, what is the current market scenario, and if there is any external technology base which would help us for launching the product in the market. Skip this. So in a company, we should be aware of what are our core patterns and what are our important patterns. So other patterns, you can say it's less important, but core patterns should be protected fiercely, and we should always look for opportunities of licensing or commercialization of such patents. So this is about technology transfer. So when we are talking about this technology transfer, it's actually about moving innovation from one entity to another, like in universities or corporations or individuals. And why we should look for technology transfers? One is that to improve the efficiency. The second one is that when we are interested in commercializing our products, and to adapt to the evolving markets. So when we talk about commercialization, it's like transforming technologies into market-ready products.
Sir,
And here we
sir,
would...
Abhishek sir, sorry to interrupt you. We already exceed the 10 minutes.
We are overshot.
Actually, other speaker are waiting. So
Okay,
please
okay.
wrap up your topic, sir, please.
Yeah, sure. Just give me 1 minute.
Sure, sir.
One minute. Okay. So, and to adapt to the evolving markets. So in licensing also we have exclusivity, non-exclusivity. where we would like to go for a revenue generation or market expansion. So that's all. And for the closing remarks as of now, I would like to conclude that intellectual property is not just a legal formality, and we should take it as a strategic business asset. And when we are trying to innovate, and when we are trying to nurture the innovation, we should also look into its protection and commercialization and how we can effectively commercialize this. And whether we are entrepreneurs or whether we are researchers or a corporate leader, we should understand and value our IP, so that it's essential to turn our ideas into actual market impact. And thank you.
Thank you, sir. Thank you very much for your insights and detailed presentation. Now, I would like to invite our second speaker, Miss Monica Tanna. She is a partner of Singhania and Company LLP. Uh, Over to you, Miss Monica ji.
Good afternoon to one and all present here. First of all, thank you for being here today. And I truly appreciate each one of you for taking times out of your busy schedule in working in the middle of a working day. Today, I'll be speaking on a topic that becomes increasingly critical, that is IP dispute management for startups. What to do when someone copies you. Before I begin, I would like to say that startups is like having a great idea and it is just the beginning. But protecting that idea is what makes truly yours. For example, let us begin with a simple example, but a powerful one. What is it that truly drives the value of a startup? Is it the team, the product, or the opportunity? More often, these startups is where the founder who has started up a startup will believe that he will have a solution, he will share the ideas, he will have a product to show, and then he goes into the market, he meets people, he will talk about the demos products, he will talk about its services, he will talk about its product, and there it comes out where his ideas have been shared with people around. And then it becomes visible, and that visibility becomes vulnerability. What is it that protects the vulnerability? Is it the intellectual property? Yes. Intellectual property is basically that products whatever the vulnerability of your demo, your products, your ideas, that it protects legally, and that is where you become the author of your product, your services, and your demo, whatever the services the IP is giving you. Now, intellectual property or IP is a phrase that is very abstract. You will feel, why is it necessary? It is not tangible. You cannot protect it by land or machinery, or you cannot feel its presence. Intellectual property is basically required to show why it, you can say, you can feel its presence by protecting legally. There is a commercial identity and it gives you a legal recognition in a market. It is a human creativity and innovation to protect your legal rights that protects the intangible yet immensely valuable outputs of your mind. There are several types of intellectual property. You might be, people present here might be knowing what are the types of intellectual property. For example, there are basic copyright, trademarks. Trademarks is a word that people keep on hearing every now and then, whether it is a startup, any businessman, any legal person, or in any other services. Second, you might have heard that is patents, copyrights, and trade secrets. Trade secrets is some word which is not really recognized in India, I must say, but trade secrets can be implemented and used while you're making your agreements or during your business foundation or something, the new ideas that you want to bring into your market. I'll give you an example of a copyright. What is copyright? Copyright is something which is an originality of a person in the form of artistic, musical, or dramatic works. If you write a book, develop software, shoot a short film, or compose a song, then the copyright comes into the picture. Registration of copyright is not mandatory, but I must specify if you go for a copyright with your first creativity, that will claim your legal disputes. And it will strengthen if any legal disputes you might have it in future. Second is trademark. Trademark is basically a protecting of a brand identity. For example, a trademark you can happen of logo, tagline, or even a specific color scheme associated with a product or service. For example, the names like Apple, Google, or Nike are the symbols that carry reputation, trust, and commercial weight. So there the trademarks come into the picture. Next, we come into is patents. What is patent? Patent is something which is your original invention, whether it is of a new product, new process, new services, that is called patent. Patent gives you a temporary monopoly in exchange of public disclosure, encouraging innovation while ensuring society progress. For example, Einstein has innovated some new product or new services. That is where the patents come into the picture. Next, we come into is trade secret. What is trade secret? Trade secret is basically where a startup can be protected under a contractual obligations and equitable doctrines, where you can protect your algorithm, your way the company is going to function, your innovative ideas, your demo products, the clientele data, and any operational know-how of how will a company gain a competitive edge. Let us give you an example. It was last month when a client approached me saying that it had built a product into a very innovative ideas. Then it started pitching into the market. It started sharing its ideas, products, and started giving on a social media presence. Everything was quite settled for a startup. The founder had come and approached us. So in that case, it happened that one fine day, he just came to us and he said that his startup was having a good functioning. It was gaining a name in the market. But then he got a legal notice saying that his service or his product has not been IP protected. That time he came and he asked us a question. What went wrong? I was going into the market. I started sharing my services. I started sharing my ideas. What is that what happened? Why did I get this legal notice? As a startup, the founder was totally unaware and a layman to what IP protection is. Then he started questioning me, saying, was it the investor meeting where I shared too much before starting the innovative ideas? Was it somewhere the management did not happen? Or how is it like that we fall into a legal trouble as soon as you share your ideas in the market? This was something which any founder of a startup was disrupted by listening into this, as he was not aware about whatever the legal repercussions he might face because there was no IP protection given to it. When startups fail to identify or register or assign or document their intellectual property, they leave their most valuable assets exposed. For example, being a startup, the startups are not very well monetary functioned. They are just growing their business. They are not supported with too much other legal persons, or there is no protection given to it. What happens to their services? It gets exposed into the market. There is an example of it that when you are having a meeting and the opposite side, there is a person who is far more experienced than you. They will listen to your ideas, they will adopt your ideas. But one day you come to know that that person has already copied your idea and is much far ahead than you in the market. That time you realize that why legal IP protections are important And what happens when there is no IP protection given to your product or your services? Can we summarize it by saying protecting it legally and intelligently and strategically is what makes your product and services a legally protected one under IP? Yes, you will have to be very vigilant and keep your eyes open that as a startup, when you go into the market, you need to have a legal background as to why IP protection of any product, services on deck, or that is important to give the production to give the protection to your business. Now, talking about startups, there might be different fields of different people who are present here. There might be fashion startups, there might be wellness, then there might be IT tech startups. There might be different fields, there might be related to food and restaurant. There might be different fields of startups, people who are present here. Let's talk about fashion startups. What is fashion startups? Fashion startups is where a small unit that tries to enter into the market having their own clothing style, limited to their names, giving different patterns, giving different varieties, different culture, and with their different brand name. Then there comes a person in the opposite side having a bigger name. For example, there was a, let's take a name of company A, that is a startup, and company B is where a Zara product comes into the picture. Then they listen to the ideas of a startup, they try copying, they try imitating. But as Zara, a well-fashioned brand which is recognized in the market, will supersede the idea or any other product that the startup is going to launch. Therefore, for the fashion startups, there are following mandatory things that are required to protect. You have to register your trademarks for brand names, logos, and slogans. Second, you might even protect your design. That comes under Designing Protection Act for clothing, accessories, and packaging. Keep a detailed archive of original sketches, prototypes, and launch dates to prove authorship. And then in the fashion trends move, as fashion trends move fast, legal protection must move faster. Because an industry where visibility is everything and inspiration borders on imitation, your brand surely needs to be defensible as it is desirable. Without the protecting of your brand, the startup will not gain any legal recognition in the market. Second example I would like to give you is about technology, that is pitching with protection. And there are different softwares, there are different design apps, data driven process that might have a startup to build its business or give its function. That also needs to be first filed by IP protection. Then there might be copyright sources. You need to have patent protection for novel technical solutions. And the most important thing for the trade IT protection is use of NDAs in pitch meetings, especially before revealing sensitive architecture. Then you need to use trademark product names, interface elements, or icons that define brand identity. Let me tell you why NDA. NDA is a non-disclosure agreement. Now you sign an agreement with your employee who is helping you to give this software protection. You need to put a clause in your agreement that this, in case the employee resigns tomorrow or something happens or he gets terminated, he is not allowed to use this software after resigning from your company. In fact, it is like in technology, it's not just about building fast, it's about protecting smart. Because in a space where investors, technology watch closely, your strength of your IP could only be lying between scaling and being sidelined. Therefore, IP plays an important role in technology field or industry. Next comes food and beverage. This is the most upcoming field in the market. Why? Because food and beverage, there are different ways, different varieties, different products that you can put it in the market. For food, there are recipes. Then there might be small beverage startup which might be using botanical sodas, hand designed bottles. They might be having aesthetic appeal of the products in the restaurant, or something who might be investing in that. Why startup can use this as an IP protection for food and beverage? Because you can even trademark, or you can just protect your recipes, you can protect your products that you are using. That will help you to have a monopoly on your recipes and products that might be used in the food and the beverage startups. If that doesn't happen, let me tell you all, the brand they might build now as a doppelganger with a distribution power. There might be a superior brand that might come into the market, and they might copy your recipes and they might copy your products which your own food or the beverage startup might be using. Next we come on to is health and wellness startups. Health and wellness startups is utmost important today in the world. Health and wellness, people do give the health and wellness the utmost priority. What happens in health and wellness startups? It gives you a wellness startups develops a behavior based 12-week nutrition program combining psychology and AI driven meal planning. It gives you an entire schedule, it gives you a routine, what you have to follow, why you have to follow. And there are program materials written, there are visuals, there are audios. For example, in the wellness spa or anything, you give you are the nutritionist or the person who advises you, they might be having a video. They might be having a video that can also be copyright. Then there are names, they give you an entire planning, how you have to do, what you have to do. That all might also be a trademark certified under IP protection. You have to keep all your wellness related products, your institution, your work for hire agreements, everything should be protected as per the IP requirement before somebody else comes who has the upper hand, then your startups to come and take away your ideas. In wellness, the method is your medicine, but what happens is your credibility is the first casualty. Protecting your process means trusting the customer's place in you. Next comes the gaming and entertaining startups. Gaming and entertaining startups are something which is also an upcoming trend. It happens that gaming startups, you might start with a new gaming that has come into the picture. For example, the recent gaming program that is Tarak Mehta Ka Ulta Chashma, which has come, the game has, you cannot copy that thing. There is a copyright, trademark, everything that gives you into it. There are specific color palettes that you might have to use. Everything, every gaming and startups helps you to just copyright your assets, file trademarks, or document their creative timeline. They are forced to watch their vision commercialized by someone else at a scale. Which trademarks, what type of trademarks can be used for gaming startups? Copyright visuals and audio assets, trademark game little logos, signatures, log all creative milestones. Consider design patents for unique gameplay, interfaces, or user control. Next we come into is if there is a dispute management into this where somebody has already copied you. What type of agreements in IP dispute management for startups? There are several managements and several type of agreements that are required to protect your interest as a founder when an employee or some other person comes into your startup for an employment. First is NDA. Let us explore into what NDA is and what is the most important role in NDA for managing IP dispute and protecting a startup foundational asset. NDA, the purpose of NDA is to prevent unauthorized disclosure or use of confidential information, trade secrets, or proprietary materials. Startups often engage with investors advisors, freelancers, developers, and collaborators. Without a NDA, there is no legal obligation to maintain confidentiality. One more thing I would like to mention is NDA is enforceable as a valid contract under Indian Contract Act 1872, and violation of NDA can amount to breach of contract. Therefore, every founders of these startups must keep in mind to enter into NDA so that there are no scopes of any dispute relating to IP management arising in future. Key clauses to include in NDA is definition of confidential information, permitted use, obligations, term, and survival. What do you mean by permitted use? Limit the purpose for which the information is shared. Once if you put a clause, the person with whom you have signed the NDA is bound or restricted for the purpose in to what extent he should use the particular service or product. Without an NDA, a startup disclosing an idea in a pitch or consultation is essentially giving away the blueprint with no recourse if it's copied. Second is IP assignment agreements. What is IP assignment agreements? IP assignment agreement is where a founder is entering into an agreement where a particular assignment rights have been given to another party. This means that a developer who codes a product feature or a designer who creates a company logo may retain IP rights if there is no IP assignment clause in place. The person with whom the IP assignment agreement is signed is not allowed to use this assignment anywhere outside the company. His rights are restricted. What are the key clauses an IP assignment agreement should have? Clear description of work, scope of assignment, waive of moral rights, confirmation that the assigner has the right to sign. Failure to secure assignment of IP can lead to painful disputes down the line, including loss of the rights to the very product you are trying to commercialize. Next comes is employment and contractor agreements. What is employment and contractor agreements in IP ownership? Every employment or independent contractor agreement must include IP ownership provisions, ensuring that IP created during the course of work is automatically owned by startup. In India, while the Copyright Act presumes that IP created by an employee in the course of employment begins to employer, hence for freelancers or consultants, a clear IP assignment clause is absolutely essential. What is IP agreement? Work for hire clause or custom related clause. It means defining the scope of employment. Then why IP clause is essential? IP clause assigning all IP created during and related employment to the company. And the most foremost thing that is required is a confidentiality clause. Confidentiality clause preventing disclosure of sensitive business information. A signed employment agreement is more than a HR formality, which helps the startups not to enter into any legal disputes in the near future. Next is founder agreements. What is a founder agreement? Dispute between a co-founders can be just as damaging as external infringement. For example, there are two co-founders. In many cases, it might be one founder may leave and later claim rights over IP they helped build. A well-structured founder agreement can prevent such outcomes by setting clear expectation and IP ownership terms. So there, even this founder, 1 minute. This founders agreement will even help you to protect if there are any disputes between two co-founders where there are chances that one of the co-founder might likely leave the company in near future. What are the clauses that are included in this agreement? IP ownership, roles and responsibilities of each co-founder, what is their contribution, exit clauses, what happens to shares, and what happens to their IP, if anything, that has been introduced in their company, non-compete and non-solicit clause. Next comes is licensing agreement. What is licensing agreement? When startups collaborate or monetize their IP through external partnership, licensing agreement becomes critical. Whether licensing software, trademarks, products designs, or educational content. How does the startups must define the licensing agreement? First is scope, next is territory and jurisdiction, exclusivity, royalty, termination, and breach remedies. What happens if there is improper licensing agreement? Improper licensing agreement, the consequences are that it can result in the loss of control, worse, or licensee attempting to assert ownership through the usage. A good license agreement enables growth, and bad one invites exploitation of a startup in the market. Next, why do IP disputes happen? What happens that gives rise to the startups having the IP disputes in their own company? A common legal issue is the assumption that mere creation confers unchallengeable ownership. Under Copyright Act, the first owner of a copyrighted work is creator unless a valid assignment has been executed. Another recurring cause is the trademark conflict. A startup may unknowingly, you say, like, a startup may unknowingly adopt a brand name that is phonetically or visually similar to an existing mark. There are many cases which have recently come into the picture that this phonetically and similar trademarks is a very big trademark litigation that gives rise to trademark infringement. And one more thing I would like to specify, such this litigation and misuse of phonetically or similarly marked provides for both civil and criminal remedies for infringement. Startups that fail to conduct preliminary clearance searches or neglect registration becomes easy target. Disputes also often that's co-founders who are part without clear documentation of IP rights. When products are developed in the informal phases before incorporation or formal equity, distribution disagreements about ownership often surface later. Next we come is what happens when an IP dispute arises. IP dispute can manifest in various forms. How do startups founders come to know that there are IP disputes which has begun in their company? A founder may receive a legal notice from a competitor, a cease and desist letter alleging trademark or copyright infringement, a takedown request from a hosting platform, or even if you say a lawsuit filed in the court of competent jurisdiction. These all legal disputes, the startup company might face a disruptive, costly, and reputation damaging, especially if investors or customers or partners become aware. That is not a good sign for a startup to enter into a legal dispute. Next, we come into is what are the repercussions if a startup enters into a legal dispute? An emotional, informal, or a public facing reaction to an IP claim can backfire legally and strategically. Any communication made without legal counsel may be introduced as an admission or inconsistent statement made under evidentiary rules. What are step by step legal response to an IP dispute? First thing, I would like everybody to take a note that do not ignore a legal notice. Silence is rarely interpreted in your favor. Ignoring a legal notice could be construed as a waiver of a defense or result in an ex parte injunction. Ex parte injunction is a term where if any matter is filed in the court and in your absence the other party can take an injunction of you not using the product or of you not giving the services. Therefore, any if you receive a legal notice, you are requested to please reply, and silence is not going to take in your favor. Next is preserve all evidence. All evidence, I specifically mean emails, development logs, code repositories, wireframes, design files, and communication with the contributors. Electronic recordings are admissible as evidence if their integrity is preserved. Next, avoid informal communication. What is informal communication? Founders must resist the urge to respond personally via email, social media, or informal channels. A misplaced statement can be introduced in litigation and may affect injunctive relief. All communications, if required, if the founders feel that there might be a legal dispute, all communications should be handled by a legal counsel or an authorized representative. Next, you have to consult an IP counsel. Any advocate or a lawyer who is trained in IP laws can evaluate the merits of the claim and respond accordingly. Legal counsel can also advise whether to take a pre-litigation measures such as filing of caveats or to prevent any ex parte injunctions or to even prepare counterclaims if your IP has been infringed. Second, I would like to suggest is explore settlement or ADR options. Settlement is the best option for the startups as the startups are not really monetary well settled in case if there is any other company who is into the market since long time may misuse or take advantage of their upper hand or their reputation in the market. Whenever possible, startups should notify investors when relevant. If the disputes could impact product delivery, public reputation, legal liability, it is advisable to inform the investors of your startups. Failing to disclose material risk may trigger concerns, and you may even be liable to enter into the SEBI regulations if required. Preventive measures and legal discipline. The best way to handle IP dispute is to prevent them. A startup that institutes legal discipline in its early days builds long-term resilience and enhances investors' confidence. Next, I would like is what are the document practices? Startups must institutionalize proper version control systems, digital laws, and maintain a proper documents of your logo, your services, anything that is required for near future for IP protection, or you never know in case if there are any litigation that may arise in near future. Last, I would like to conclude by saying is we have walked through the core reasons dispute arise from an unassigned IP and unclear ownership. We have got to know what are the basic rights and protections that a startup must need so that you do not enter into any legal dispute. I leave with a question which says, if someone copied your idea tomorrow, would you be ready not just emotionally, but legally to fight for what have you created?
Thank you very much for your presentation, Miss Monica. Now
Thank
I
you so
would
much.
like to invite our next speaker, Mr. Pulkit Dogar. He is the partner of Lakshmi Kumaran and Sridharan. Sir, over to you.
Thank you very much, Akshat. And I'd like to first of all thank everyone here for being present and for the entire team for taking this initiative and giving us the opportunity to contribute in this initiative. I'll just start sharing my screen. And I must, at the very beginning, apologize for my voice. I have a bit of a bad throat, so please, I apologize for that upfront. Today, I'm going to be talking strategic planning. I will be talking about strategic planning and patentability assessment, especially in the context of patents. The speakers before me, they have already touched upon different aspects of intellectual property, different kinds of intellectual property. So I will not revisit all those aspects, and I will limit my focus today only on patents. Before we start, let's understand why the patentability assessment. Why must somebody trying to get a patent assess patentability? The fundamental principle based on which the patent law exists is that there is a reciprocity between the government and innovators. This reciprocity is by way of the government allowing a controlled monopoly of 20 years in exchange for information from the innovators, which can allow uh, other innovators to develop and build on that information. And that way, research and development is fostered. Because we talk about a controlled monopoly, especially in the case of patents, the monopoly can be, in certain cases when enforced, it can be strict to say the least. Therefore, the law, the courts, and the authorities like the patent office, they sit as custodians to protect the public right while providing monopoly or this controlled monopoly to the innovators. So that is the context of what I'm going to be talking about, that how when, as I said, that there are these entities that act as custodians, what is it that they look for when they are doing the patentability assessment, and how startups and small companies can do that on their own. Again, I will very quickly skim through some of the aspects because they have already been touched upon. Especially in terms of patents, what we must understand is that they are territorial in nature. That means a patent which is granted in a specific jurisdiction, such as India or US or Europe or China or Japan, is limited in its enforcement only in those jurisdictions. The second thing that we must understand, that it provides you a controlled exclusivity. And the third thing, that this is a limited time exclusivity that you can enjoy. The speakers before me have already spoken about how a one-size-fits-all approach for protecting innovation, for business strategy, for IP strategy does not work. This slide actually talks on similar lines, that you can have different kinds of innovations, and you will your strategy, your IP strategy will require you to find out how do you protect these different kinds of innovations by way of different kinds of intellectual property rights. This slide only records different kinds of IP protections and their terms. I'll just quickly skim through that. Again, same thing, that there is one product which can have multiple kinds of IPRs, and when you're working your business strategy out, you must look at the product holistically and see how you can best protect your rights by way of these multiple IPRs. Let's now dig a little deeper, that why must you patent? Now for a business, these patents will provide a competitive edge and allow innovators to position themselves in the market at a certain advantage, as well as create a brand value, which will allow you to garner the trust of your customers and help you with brand recognition. This, of course, this holds true for trademarks. What people do miss sometimes is that in terms of technological quality and innovation, the brand recognition and that customer trust can be built similarly by way of patent protection. Why is it beneficial to inventors? Inventors, of course, the first and foremost thing is that they can enjoy exclusive rights that control monopoly that we have been talking about. They can get recognition for their contributions to the research and development of technology space. And there can be the applicants, companies, they can allow for some monetary gains. And of course, through licensing and commercialization, they can reap financial rewards. Now, let me talking about copyrights, trademarks, patents, trade secrets, all of that. Let me dig a little deeper into what patents are. If I was to sum up in a single sentence, patents are the form of intellectual property that will provide protection on technological innovation. The technical definition is that an invention is a new product or process. And as we will go further into this discussion, we will also understand that what are the different requirements for patentability assessment and for patenting that companies, startups, small businesses, and innovators must bear in mind when they are assessing them for patentability. Of course, like I said, that the patents will allow you a controlled monopoly for 5 things: making, using, selling, offering to sell, or importing a patented product or a product made by a patented process in the territory of India. Similar rights are granted in other jurisdictions also. There might be some variations, but fundamentally, this is the kind of right that a patent affords to a patentee. What are the different kinds of patents? Now, fundamentally, there are 3 different kinds of patents. The first one are referred to as utility patents, which I mentioned protect technological innovations. You would see on the slide that there are certain examples that we've included, that patents on improvement of transmission of telecom signals or improvement of network efficiency and reliability fall under the category of utility patents. Similarly, a new engine design which allows you for a higher efficiency engine would also fall under the category of utility patents. The second kind of patents are design patents, which will protect the aesthetic or the ornamental design of an article. These, while we refer to them as functional items, I must create a very clear distinction that design patents will protect only the aesthetic or the ornamental design and not the function. For protecting the function, you must fall back on utility patents. The utility patents are, like I said, they are the basis is technological innovation. Sorry. And therefore, they give a more comprehensive protection. However, the process is significantly longer. Design patents, because their assessment is purely on the basis of aesthetic and the ornamental design, so they are easier to assess, and therefore the life cycle in processing this through the authorities and getting an allowance is significantly shorter. The third kind of patents are plant variety protection patents, which will allow you for protection on genetically modified plants and crops and other kinds of such plant varieties. As you will find that even within patents, these 3 categories of protection create a very specific kind of protection for a very different kind of aspect in all these 3 cases. Now, I move to what can be patented. But before I go into this, I must admit that in my in all the time that I have been working, and I work with a lot of small companies and startups and individual innovators, and I find that there is a notion that for getting a patent, the innovation must be path breaking. That there are software, if your innovation lies in a software, it cannot be patented. Today, as I go through this discussion with you, I want to correct those notions and make it clear that innovation, whether it is like Mr. Sen mentioned, whether it is radical or incremental, an innovation is an innovation. And if it meets the different requirements which are laid out by the law, the propensity of the innovation is immaterial in getting a patent. So I had alluded earlier that the technical definition of an invention includes three things: that it must be a product or a process which is new, which must involve an inventive step, and which must be industrially applicable. Each of these benchmarks are individual requirements. They must be individually fulfilled, must be individually met. It's not an or requirement, it's an and requirement. Your innovation must be new, and it must be inventive, and it must meet the industrial applicability requirement. So let's talk about new novelty. Novelty is a sorry, it's an objective requirement. It's a black and white assessment that your innovation must be new, and it must not be known. It must not be known by way of any public disclosure. These disclosures can be in the form of a publication, a video, a blog, a white paper, any other patent, an audio clip, anything. Even public use in certain cases will amount to destruction of the novelty of your innovation. So this is the primary requirement that your innovation must meet, that it must be new. It must not be known to anyone before your date of invention. The second requirement, and which becomes a little objective in its criteria, is that your innovation must demonstrate an inventive step. Again, the technical definition of inventive step is that your innovation must have a feature which allows for it to have a technical advance or an economic significance, which means that your innovation must either be technically better or it must be economically better than the existing innovation in this field. And the last requirement that you will also read here is that it must be not obvious to experts in this field. There is a notional entity of a person skilled in the art, which refers to the expert in the field. And your innovation must meet the criteria that even if your innovation is new, that you have made a modification which is not known by way of any other public disclosure, but it must be so that innovation must be so that an expert in that field must not be able to, by way of a workshop modification, be able to arrive at that innovation. Let me take a very simple example here. And I think you must have heard this example because I think it's a very widely circulated example. So forgive me if I'm giving this example at the cost of being repetitive. But let's say that four-legged chairs have always existed. And somebody invented a moving chair by attaching wheels to that chair. Now, if wheelchairs had not existed before that, then your innovation will meet the requirement of newness. Because it is not known publicly by way of any public disclosure, a wheelchair would amount to a novel innovation. But the question that then remains is whether it will amount to an inventive step. Whether an expert in that field, knowing that wheels have already been innovated, there are trolleys, there are trams, there are bullock carts which are using wheels. I can simply use that to make a chair mobile. Again, I am oversimplifying maybe for the sake of everybody's understanding. And in most cases, you will find that the inventive step assessment is not that easy. However, the requirement must be borne in mind. The last requirement is of industrial applicability. When we talk about industrial applicability, the requirement is fairly simple and the yardstick fairly easy to use. If it has a practical use in an industry, it can be applied in an industry, it can be manufactured by way of an industrial process, then it will meet the requirement of industrial applicability. In my tenure as a patent attorney, I have not seen till date a rejection of a patent on the basis of industrial applicability. So it is safe for me to say that the industrial applicability requirement is probably the easiest requirement that your innovation can meet. So if I was to summarize, there are three requirements that have been laid down by the law for an innovation to qualify as an invention. It must be new, it must be inventive, and it must be industrially applicable. And I will go back to the point that I was trying to make, that I have found many small companies, startups, especially sorry, people who have not been IP savvy, for them to understand that for you to get a patent, or for one to get a patent, the innovation must be path breaking. It must, and I must go back to again what Mr. Sen said. He said there are three things that an innovation must do. It must create an impact, it must change lives, and it must solve a problem. And if your innovation is doing any of these things and it falls under the technical realm, you can get a patent on that. Let me give you an example, a very simple modification. I'm not sure if people are aware of two-stroke, engine technology, but I will keep the technical details to the minimum, and I'll try to keep them as simple as possible for everybody to be able to understand. One of the processes in a two-stroke engine is called scavenging, where the piston starts moving upwards and there are open ports at the top, and the upward movement of the piston causes the air to be pushed out. Right now, one of the requirements of engines is that the mixing, when this air is being pushed out, the mixing of the air and fuel must be done well, for the fuel to be able to burn well, and so that the emissions can be controlled. There was an innovation where the inventor had created angled holes on the sides of the cylinder, so as the piston moved up, there was a swirling motion of that air, because of which there was high turbulence that was created as the air moved, as the piston moved upward. And the emissions were reduced by as much as 30%, just by that simple innovation. So the point that I'm trying to make here is that when you look at it in isolation, the only change that has been made is the holes which were otherwise straight, they have been made to be inclined. But the impact and the problem that it is solving has a far bigger import. And that is something that especially startups and small companies that are not very IP savvy must bear in mind, that the requirement of patentability is not hinged on the fact that your innovation must be path-breaking. So here I've spoken about the patentability requirements from the viewpoint of what an innovation is or what an invention is. In addition to these requirements, there are certain other requirements that your innovations must meet. by way of this image, you will see that at the top of the pyramid sits inventions. So your inventions must meet the criteria of newness, inventiveness, and industrial applicability that I was talking about earlier. But at the same time, there are two further requirements that your innovation must meet. I'll first talk about enabling disclosure. You will remember right when I started, I spoke about the fundamental principle of patent law, that it's a reciprocity engagement or a reciprocity arrangement between the government and innovators. That the innovators will get a controlled monopoly in exchange for disclosure, and that disclosure must meet the requirement that it is an enabling disclosure. I will not go into a lot of detail here, but suffices it to say here that especially because we are seeing a lot of innovation in the field of AI. AI and GPTs and these models, and the requirement of enablement of. So when we talk about an enabling disclosure, it essentially means that an expert in this field, somebody who exists, has been working in that field, should be able to use that disclosure, the information that you have disclosed. That information must be sufficient for somebody to be able to carry out the invention. Again, it's not as simple as it sounds, but the yardstick of providing the disclosure is not as strict as, for example, know-how transfer. You do not need to transfer the entire know-how for your disclosure to be enabled. And as I said earlier, because we are talking about, or in today's day and age, we are talking about innovations which are related to artificial intelligence and these models where we are using training data and neural networks. So the requirement of an enabling disclosure becomes all the more important. Lastly, the requirement is of patentable subject matter. Now, there are certain categories of innovations which for public good have been carved out as exceptions that you cannot get a patent on that. I will not divulge into details because I see Akshat, he's switched on his video. Probably I've overshot my time. So I will quickly now wrap up. But when we talk about patentable subject matter, there is a whole list of categories of inventions that have been carved out that you cannot get a patent on that. One of them is inventions which are related to atomic energy. And then there would be other categories that you would find that they are, fundamentally, it's incorrect to allow somebody to get a monopoly on that. For example, innovations which claim that they go against established universal laws, or innovations which are already known by way of, let's say, traditional knowledge or mere combination or mere admixtures. And then there are certain categories of innovations which can allow an undue advantage to the entity that gets that monopoly. For example, if you are allowed innovation on business methods or mathematical methods or methods of treatment, then the monopoly may be skewed in favor of the innovator and not and the public interest may be adversely affected. So that, along with those three requirements of an innovation to amount to an invention, there are these other requirements that have been laid down by the law, where the custodians will apply these yardsticks to make sure that there is a balancing act between the public good and the rights that an innovator can claim. I will very quickly, I had taken some examples that there are some simple ideas, but they amount to patentable inventions. For example, as flexible straw or a U-pin or a paperclip. All these are patented. We've taken screenshots from US patents, so these are all patented technologies. And before I go, Akshat, I will just quickly talk about the first two steps, because I think these are very important for startups and small companies to understand that as part of your process of identifying innovations and then assessing them for patentability, the first two steps become most important. The first step is of invention mining, where you must record all your ideas. What are the problems that they're solving? What is the solution? How the solution has been implemented? You evaluate, does that amount to a technical innovation or not? And these can be incremental in nature. Please do not disregard simple ideas, or at least ideas that seem simple. Assessment of these ideas may give you very surprising results. And the second thing that I wanted to talk about was a prior art search. So once you've identified the idea, the concept, it is important for you to perform a patentability assessment by way of a prior art search to find out that what are the publicly available documents which either disclose similar aspects or technologies which are similar to yours. And by way of that, you can refine your innovation to find that sweet spot where you can actually apply for a patent to protect your innovation. So with that, I do have some other slides, but I think I can close here. And what I will do is that I will leave my email ID in the comments, and you can please feel free to reach out to me with any questions that you might have. Thank you very much. Thank you, Akshat, and thank you everyone for very patiently listening to me. Thank you.
Thank you, sir. Thank you very much. And we will share all the presentation with the participant with the thanks mail. So they will get your contact detail in that PPT and they will reach out to you. So now I would like to invite our next speaker, Miss Indumati Ji. She is the associate partner from the Kocher and Company. So over to you, ma'am. Please.
Hi, Akshat. Thank you for the introduction. Is my screen visible and am I audible?
Yeah, you are audible. Your screen is visible, but your video is not visible.
Okay, just one second. Okay,
Yes.
am I visible?
Yes, now you are visible. Please
Yeah.
start.
Perfect. Good evening, everyone. It's such a pleasure to meet everyone here. And thank you for my co-panelists for beautifully covering all those topics. And thank you, Akshat, for the opportunity. So since we're already running late, I'll just quickly start my presentation. Yes. So my topic today is trademarks prosecution. So my co-panelists have already covered or given you an idea as to what a trademark is and how important it is.
Sorry to interrupt you, ma'am. Your presentation is not visible. Yeah, the folder is visible only. That you.
Okay, just one second. Is it visible now?
Yes, now it's visible.
Okay. Okay. Yeah. Is it visible now?
Yes, it's visible.
Yeah. So a great man once said, "What's in a name? That's which we call a rose by any other name would smell as sweet." Who is William Shakespeare? So he had given this, a lot of years back. But little did he know that after many years there would be a lot of pop-ups, a lot of restaurants, hotels that will come up in his name. So if he had been alive today, he himself would be confused by the kind of trademarks people have been filing in his name. So that's how important a trademark is. So a lot of people tend to skip this step before you adopt any trademark. The very important and the key step is to understand how to choose the right trademark, because that saves you a lot of financial stress. It gives you an edge over everybody in the market, and this is the most important step that we would suggest that you don't skip at any given chance. So the first step is to identify the right trademark, like I said, and these are some of the advices that we would give to keep in your mind when you come up with a new trademark. One, it has to be easy to read, spell, pronounce, and remember, because when people, the key aspect is for people to remember your trademark when they're impressed with your product or service and pass it on to next people, to public, to say that I bought a product under this brand and this is so good and you should also try. By that time they should be able to remember the brand and convey it and pass it on to the to the public. So it has to be easy to read, spell, pronounce, and remember as well. Two, it should not have any adverse meaning. Like, even in the local languages or any language, it is important to make sure that it does not have any adverse meaning in any slang also. And three, the most important is it has to be new, invented, coined, and unique. The more inventiveness you put into the market, to the mark, it is easier for the mark to get registered. A lot of times people tend to pick terms that are very common, to the we will see the examples in the next few slides, but to just give you an introduction, a lot of people tend to pick marks that are very common, like to call a bottle a bottle. People, it is not, it is important to understand that it is for everybody to call a bottle, and a monopoly cannot be granted to one person to call a bottle a bottle. So there has to be a uniqueness to your mark, and there can be various innovative steps that you can take to coin your trademark. Sometimes we tend to address advise our clients saying that you can take the first letters of your partners in the firm and coin it all together. The trademark need not necessarily have any meaning. It can be a meaningless word also. So, the more meaningless it is, the easier it is to get it registered also. Four, does not have any exclusive descriptive dictionary words, generic words, surname, or shorter acronym. Like I've given example, you can call a bottle in any other name, but not bottle. So it should not describe the exact product for which, the product that you would be offering under your mark. If I'm going to sell a pen, I cannot say, I cannot use Right as my brand, because the moment I hear about Right, I can obviously think that it is something that is related to something that is used to write. So the mark should not in anywhere indicate that the product is for this, the mark is for this. It has to have a five. It should have a distinctive logo. This is not a mandatory step for the mark to have a distinctive logo, but having a distinctive logo to your mark will enhance or better your registration chances. Six, it should not be confusingly similar. Sometimes, you tend to come up with marks that are really unique, coined, but sometimes, there is meeting of minds and there is a chance that there is another third party who has already registered this mark in the trademark registry. So it is important for you to also make sure that even though the term is coined and invented, it is not similar to any of the existing trademarks, especially well-known trademarks that are in the market. So I'll give you an example scenario. So I'll just take you through a process where, now we are trying to pick a trademark for a tractor, for an example. So I have given you 5 options. One is tractor, 2 drive plus, wheel roll, cheetah, and pneumatic. So now that I would advise, I would call you all to think of one of this option in your mind. If you were to, bring a new tractor into the market, which of these 5 options would you choose? So you can just keep it in your mind and we'll see which is the most registrable trademark. So the first trademark the first option was tractor. If you see, I have tweaked the, spelling of tractor in this mark. But still, at the end of it, it still sounds the exact product for which I'm trying to adopt this trademark for. So for the same reason, this is a very, very weak trademark. It is very unlikely to get registered just because of the reason that, it directly indicates the kind of products that I'm trying to sell under this product, under this brand. So it is also generic and directly indicates the goods and cannot be distinguished because there can be multiple other brands that are adopted for tractor where there can be a suffix or prefix of tractor, the term tractor, just because it is the exact product that they are trying to sell. So therefore, no monopoly can be granted, even though you tweak the mark in phonetically to look it like a different mark. But at the end of the day, it is the same phonetic sound. So this is the most weakest option of the 5 options that I have given. The option 2 is drive plus. So this mark is a little better than the option 1, but still, it needs a lot of enhancement to be easily registrable. Because, the moment I hear about drive plus, I can know that, this mark is something that is related to something that I can drive. Sometimes you are allowed to adopt marks that are descriptive such as this, but in a very few situations, such as where you have used the mark for a very, very long time, and people have started associating this mark with you and nobody else, and so that but to establish that people have started using associating this mark with you, you will need voluminous user documents to support and say that I have adopted from so long years and people have already started associating this mark with me, and therefore if this mark is not granted to me, it would be it would be a detriment to my rights and to public's interest. The option 3 is wheel roll. This is again a little better than the earlier 2 options because this implies the purpose but does not directly indicate it in any manner. You can, of course, think that this is something that is related to driving, but still there can be chances that you can interpret it to fall under various other goods, but just not the tractors. So this is suggestive, but still it needs a lot of imaginary elements to be put to be better registrable. The option 4 is cheetah. Here, this mark cheetah is a common English term, but even though it does not directly in any manner indicate that it is tractors. When I would give you a simple advice where, the moment you come with a trademark, the moment you tell me the trademark, I should be in a position to ask you for what kind of goods and services you are going to adopt this mark for. I should not, the moment you tell me, I should not be able to predict, that, this mark is definitely for this. So that kind of a mark is what is stronger. So here this mark is does not directly link to the tractors. So it is arbitrary with no reference to the product at all. So this is inherently distinctive. So option 5 is pneumatic. This is best of all the options because of the reason that this does not have any meaning as far as I know. And this is a completely coined term and this has no dictionary meaning. And therefore, when you come with a term which is completely coined and new and which has no meaning, you don't even have to produce documents to substantiate why this mark needs to be registered in your name. You can completely and confidently go file your mark under proposed to be used category and have it registered for yourself. But like I said in the beginning, you should also ensure that this mark is not, that there has been no meeting of minds and there is no similar marks already in the records of the registry. That's the only step that you will have to confirm before you file this application. Otherwise, this is the strongest of all the 5 options that we saw. So where to go and confirm if my mark, but I have a mark in my mind. So where do I go and confirm, if this is, how far this is registrable? There are different platforms in which you can go search. One is obviously the trademark search in the official website of the trademark registry. You can always get in touch with trademark professionals like us to understand how far it is registrable. 2, you can do a simple Google search. It is not that you can skip one of this and do the other, but all of these needs to be done so that you are sure that you are not infringing upon anybody else's trademark. So 2 is a general Google search. Sometimes, the marks that are in the market would not reflect in the trademark registry for a reason that they would not have filed their trademark application yet in the registry. Still, they have been using this mark. So you will sometimes find marks in the Google search also, which are not reflecting in the official website. 3, search in the websites under which similar products are sold popularly, like Amazon, Flipkart, and all that, the e-commerce platforms. And sometimes in the social media platforms. Now that, in the social media platform, everybody is coming up with their own brand. Sometimes when you go search the name that is in your mind, there are high chances that somebody would have already started a business in its name and would not have probably taken steps to register the mark yet. And the last one would also be domains. So how do we file the trademark, and what process does my trademark application goes through before it gets registered? Like I said, the first option, the first step would be doing a search to understand how far my trademark is registrable and what are the potential objections that I can foresee in my trademark registration. 2 is trademark application filing. There are certain documents, procedural documents that are required for filing a trademark application based on various factors, like if you fall into what category of applicant and what kind of use you have started using or you are proposed to be used and all that. But with all those documents, necessary documents, we file the application either physically or online with the trademark registry. And then you're allotted with an application number with which you can keep a track of your application. So after you file your application, the trademark registry essentially examines your trademark application to understand how far this is registrable. There are 2 common objections that you can see during your examination stage, which is Section 9 objection and Section 11 objection, which you will see in the upcoming slides. So, and this is apart from the formality objection. Sometimes there can be formality objections wherein we require you to submit further more documents like power of attorney and all that. And after that, under legal provisions, your application gets examined, and if there are any potential objection, you're notified of that objection, and then you file a reply within the stipulated deadline. After the reply is submitted, if the registry is convinced with the reply that you have provided, then your application proceeds to the stage of publication. But in cases where the registry requires further clarification from you or further documents from you, they set you up for a hearing. During the hearing, you can appear and then let the hearing officer know that this is why I deserve this mark to be registered in my name. And if the officer is convinced, he will allow your mark to proceed to the next stage of publication. If the hearing officer feels that this mark still has the potential objection, then he can also choose to refuse this application. If you do not appear for the hearing or submit your reply in time, your application gets abandoned as well. So what happens after this publication? It's a very important step where, when your application, gets published, it basically is kept open to the public for anybody, any third party to oppose your application under certain grounds, of course. But anybody can it is not even necessary for the third party to have a registration of a mark to oppose your mark. Any third party can file an opposition against your mark. And then the opposition has its own procedure where you file opposition counter and all that, produce your evidences, and then that reaches the opposition hearing stage. So during the hearing, the officer will examine the evidences submitted by both the parties and decide if the registration has to be granted or not granted or granted with a limitation and all that. So if nobody opposes your mark, there's a time period of 4 months from the date of publication. So for this 4 months, the application is kept open to the public. So anybody can choose to oppose this application within this 4 months period. And if nobody opposes your application directly slips to the registration stage and your registration certificate will get generated and issued. But if somebody opposes, you will have to go through this opposition stage, cross through it. If you're successful in it, then your application proceeds to registration. If it's not successful, your application gets refused. Like I said, there is the common objections that the registry will come up with during examination of your application is one, like I said, the formal requirements like the power of attorney, user affidavit, and all that. Two is the legal provisions, which is Section 9 and Section 11. So Section 9, when we were discussing it in the beginning, what all to keep in mind when you come up with a trademark, I was saying that it should not be descriptive, or it should not directly indicate the products that you are trying to sell under your brand. It should not lack distinctiveness, and it should not have any obscenity and all that. So that all these factors are captured in Section 9. So if an objection is raised under Section 9, then there is the mark as attractive one of these grounds. The next popular objection that the registry raises is Section 11 objection, where the registry feels I have certain marks which I feel which are similar to your application. So you will have to substantiate why and how your application is different from the marks that the registry has cited in your examination report. Sometimes the objection can also require more user documents, or it will require you to amend your goods and services to in accordance to accept your accept your mark for publication. So accordingly, you will have to reply to the examination report. So like I said, there is a stage where third parties have rights to oppose your application for those four months period. So during those period, what are the grounds that the third party can raise an opposition against yours? Is one, is your application is devoid of any distinctive character, or it hurts any religious sentiment also. We have seen the popular news that circulated recently about Operation Sindoor, wherein a lot of people tried registering this mark soon after it became popular. There were a lot of entities also, popular entities also, who tried registering the mark and for themselves. But oppositions were filed against those those applications, because objections were raised and it was popularly discussed also, because it hurt the sentiments of India, because it is something that the government owns and the government adopted for a certain reason. So nobody can, raid on the hard-earned, reputation of that mark for their own commercial benefits. Next is it causes any confusion on behalf of public due to its identical nature of the earlier trademark. This is Section 11, like I explained. If the mark is similar to any of the existing trademarks in the records of the registry, or even away, off the records of the registry, you can file an opposition against the mark. 3, it is identical or deceptively similar without any permission. So the original owner, there are certain situations where there can be group companies where there is one common trademark which a lot of group companies file in various variations. In such cases, they will ideally have permission from the group company to file similar variations. But it is not so in every case. There are situations popularly where people tend to file very, very close variations of same mark without getting permission from the earlier registered trademark registrant. So in such cases, you can file an opposition. The fourth one is takes unfair advantage with effects of reputation, which affects the reputation of the registered trademark. The last one is applying false trademark or trade descriptions. Like I said, one of the requisites for filing the application is to disclose if you have started using the mark or not using the mark. India is a country which follows first to use principle, where even if there are two, let us take for an instance, there are two persons, A and B. A has started using their mark but has not registered the mark. B has moved to register the mark. So now who has the upper hand? One, A, who is the prior user, or B, who is the prior filing applicant? The answer would be A, because India is, like I said, India is first to use principal country, so that whoever adopts and starts using the mark first will have an upper hand, even if the other party is registered. So even against registrants, if you are a prior user and if you're able to, establish all of that, you will still have an upper hand. There are different timelines under which the trademark application is being, prosecuted, is being dealt by the trademark registry. But we are seeing a substantial delay in the, examination of the trademark applications, or, deciding the positions of the trademark registrations and all that. And Mr. Goyal has beautifully also, captured that in his various speeches. And this is one of the instances which I wanted to bring it to your notice, that in recent times the trademarks applications are really taking a considerable long time to get registered. So it is important again to emphasize here that if you come up with a easier trademark, I mean a coined and invented trademark, you can get your trademark registered quicker than a lot of other trademarks just stuck in the opposition stage or objection stage and all that. So so this is whatever we have discussed is with respect to international national trademarks in India. So when you want to grow beyond the country, and you want to file in various other platforms, various other jurisdictions, various other countries, there are different methods by which you can file your applications. So say for example, I have a trademark in India and I would like to expand it to certain countries. Then I will have to first understand the list of countries that I'm trying to protect my mark under. If I have, multiple jurisdictions that I'm trying to register my mark under, then I have a different route. But if I have very little number of countries that I'm looking at to expand, then I have a different route. We'll see that. So one is national applications. Well, it is like how we file an independent application in India. We go file an independent application in the respective countries that you're trying to expand. If I'm trying to expand into, say for example, UK, I file an application under the UK procedure. I follow whatever that is required to be filed and get it registered. Similarly, if I have in Kuwait, I file it as an individual separate application and have it registered as per the process of Kuwait trademark registration. So this is following the national application steps. Whereas if I have multiple countries that I'm looking at, there are about, say for example, 50 countries that I'm looking at, filing the application. Then there is an easier way to do it, where you can file one single application covering multiple jurisdictions, through the Madrid protocol. If it's through the national application stage, then you will have to conduct the search in respective countries. But this stage of doing a search under the respective countries is also suggested in the Madrid protocol, because before you lodge your application, it is important to ensure that your application does not have any potential chances of refusal or being similar to any of the existing trademarks in that country. So doing the search in the respective countries is recommended to be common in both the methods, national application and Madrid protocol. And then with a single application, if it is through the national application, then we file the application as per each country's requirement, and we will prosecute it also according to the local law. If it is under the Madrid protocol, we can file a single application which can help you secure registration in multiple countries. But even then, your application will be examined like a national application. But it makes your procedure simpler, because you file it with a single application and it gets prosecuted under each jurisdiction. But for that, the country has to be a member of the Madrid protocol, and thankfully India is. So I have just listed how the Madrid application process works. But since we don't have enough time, I'm not elaborating on this process, and I'll just quickly slide to the next slide. So herein I have given the advantages of Madrid application. Like I said, Madrid application has several advantages over the national application when you carefully curate it. One advantage of it, like I said, it's a simple single application which can be filed in 100+ countries in a single go, where you can protect yourself in multiple countries with single application. Two, you can file it with one single language with one set of documents. That will do. You don't have to go to every set of requirements as per every country's local law, and you will have to file. It is not that. You can file it in just one language with just one set of documents. And it also allows one set of fees. So if you have multiple countries, it is actually more cost effective to go through the Madrid filing route than the national route. But that again is only when you have multiple countries in your mind. Four, it gives you an automatic registration if there is no potential objections during the period of 12 to 18 months. So 12 to 18 months after you file your application, if you do not receive any objection, then your application is deemed to have registered. And the last one is if you have any changes, say for example, you have filed your application in about 10 different countries, through Madrid, and you have a change of ownership, or product limitation, or you have renewal of the mark, then then you will have to you can just file one single application, which will take effect and reflect in all the other jurisdictions that you have filed your Madrid application in. And when I said renewal, I would like to emphasize that your trademark registration is valid for a period of 10 years from the date of application, and it can be renewed perpetually for 10 years. You can keep renewing. There's no limit to it. And you might have a question as to when to choose Madrid and when not to choose Madrid. Like I said, when you have to choose is there are too many countries that you're looking at registering and expanding your mark. You can opt for Madrid. Then two, the search results are optimistic and you're not seeing potential chances of an objection in the registration process, then you can go ahead with the Madrid. And three, a very important thing is you should have a base application. If, say for example, so now we are from India and we are based out of India, we should have a base application based on which this entire Madrid application will be based on. I have an application here in India, and that application is registered in India, then I can confidently move and file my Madrid application based on this Indian application. So if the reason, because if your application is not registered and it is pending in certain stage, then your Madrid, if something happens to this Madrid application for the first 5 years, then the entire Madrid application system collapses. Whatever country that you have filed based on this Indian application, if something happens to this application, if it was not renewed, or if it is opposed and was refused subsequently, then that will get reflected in all your Madrid application. But there are certain places where you can still try and protect your Madrid application, but that's a different day to discuss. When not to choose this Madrid route is when you have very few countries. We have seen that the national application route is way more cost effective than the Madrid route. Two, if your base application, like I said, has potential chances of conflicts, then we would highly recommend that you do not file your application based on your Indian registration, but just file a national application. Three, if you want to transfer your own, if you're looking at transferring your trademark to a non-Madrid protocol member in future, it might have a lot of complications in transferring the ownership in a later stage. So if you foresee yourself in transferring the ownership to another entity or an individual who is part of a non-Madrid protocol country, then we would not recommend you to file in a Madrid application. Last one is non-traditional trademarks. There are different kinds of trademarks that you can file, like word mark, logo mark, sound mark, and all that. And the trademark system is evolving to include multiple other kinds of trademarks in the ambit. And one of the example that I've given is sound marks. So sound marks is not recognized in all the jurisdictions. So it is recognized in India, but it is not recognized in every other country. So if you're trying to protect yourself through Madrid, through sound marks, it is important to confirm that that kind of trademark is accepted in that particular jurisdiction. So I have just given certain case laws, but understanding that we're already running late, I'll just quickly skim you through the slides. I'll probably give you one case where, this is a very
Ma'am,
evident case.
sorry to interrupt you. We are already getting
Sure,
too much
sure. I'll just
queries,
then
so we need to
quickly,
answer that query, and we send your presentation to the participant, and they can
sure,
directly reach out to you if they have any queries.
sure.
Okay. So I request all the speakers, please switch on your video and answer all the queries which we have received in Q&A box. Miss Monica is already answer 9 queries in the Q&A box. So I request other speaker, they can also answer the queries. They can you can answer by audio also instead of typing the your answer in that. So Abhishek sir, first query we received after your presentation, that is related to the, can you explain the difference between the exclusion and limited exclusion from your starting slide?
Yeah, actually, this is a very good question. So when we are talking about this full exclusion, limited exclusion, or an open access, now these are strategies which are tailored to specific needs of a business. So what I mean is that when we are talking about a full exclusion, so this strategy would involve any IP rights like patents or copyrights or trademarks, and which would completely prevent others from using your innovation or technology. Now, the purpose is to maximize the competitive advantage by keeping others out of your market space. And if I take some use case, now this type of strategy would be ideal for companies in high competitive industries where protecting proprietary technology is crucial. It can be pharmaceutical or it can be high tech. But the implication for full exclusion is that there would be strong legal enforcement. The investment will be very high in IP protection, and there are limited opportunities for collaboration. Now, if we see the limited exclusion, so these are actually for companies where we want some controlled access to the IP. So controlled access means you want to give a license or through any partnership agreement, or you want to selectively share. So here the main purpose would be to balance the protection with collaboration, and this would enable revenue generation or any strategic alliances while you would have a full control. Not full, maybe some control on the access of your IP. And the implication would be where you need to negotiate carefully and monitor the use of your IP. And for open innovation, if we go for open innovation, so where we are trying to give open access, so this is when we are trying to promote the innovation through collaboration and also sharing our knowledge. So mostly common in academic research, then open source software, and public health initiatives.
Thank you, sir. Next question we have, do we need to Madrid application within a time limit?
To answer the question, no, there is actually no time limit within which you have to file from your base application. So you can file it at any time.
Induji, you can also check other questions in Q&A box, which we have related to your presentation in the bottom of the Q&A box.
Sure.
Right.
So there was a question where they had told that, they have filed an application in 2020 and they have replied to the examination report also, but it is still pending in the trademark registry. Just wanted to answer that question saying, like I have mentioned in the slides, the trademark registry is taking a really long time in processing all these applications. especially for the even for the examination stage itself, it is taking a long time. But there are ways by which it can be expedited by filing an expedited. Generally this is filed at the stage of filing. Because there are two different routes. One is normal route and one is expedited route. So if you had filed your application under the expedited route, it would have, it will get examined at a quicker, timeline, get decided basically on a quicker timeline. But if you have not filed it under that route, you can probably try and file the request again under the expedited route, or just you can visit the registry and follow it up at the registry to understand where exactly it is stuck. But such delays we are also facing in various, because of various factors, like, the registry has very little examiners, we're still recruiting it and all that.
So next question is whether we can conduct trademark search in all the Madrid countries through a single database or any other mechanism for search available for each country.
There is no single database through which you can, search all the applications throughout the world. Though there are certain places where you can go see for, but it is not a conclusive report. So what we always recommend is doing a national, search, according to the respective country's database, to understand a conclusive and get into a conclusive understanding if the mark is registrable or not, because a lot of times does not get reflected in the, the common database.
Next question is there any open source database for herbal technology like TKDL database?
Maybe I can take that question.
Sure, sir.
See, if the herbal technology amounts to traditional knowledge, which in my understanding, in most cases it would, I think the herbal technologies or the use of these traditional herbal recipes would also be part of your TKDL, which is your traditional knowledge digital library. So ideally, anything that is traditional knowledge, including herbal recipes, they should all be part of the TKDL.
Next question is in case of trademark opposition, if I oppose the trademark and was doing business using same or similar mark, will I be eligible to get the mark registered in my name once the opposed mark is refused?
To answer this question, if my understanding is correct, that you have opposed a mark and it is pending and you continue to use the mark, and if the opposition gets decided in your favor, if you can continue to use the mark. Yes, if your opposition gets decided in your favor, yes, you can continue to use your mark.
Next question is, given the exponential growth of AI sector and in light of the recent announcement from Denmark with respect to granting copyright to its citizens over their physical likeliness, can India also tackle AI agent deepfakes by using copyright? How can it do so?
I think we don't have a copyright expert here today, so maybe we
Okay.
can.
So we are not having this answer for this question, but we share all the question with our speak panelists so that they can answer you by email after the program. Before ending the session, sir, I would like to ask two questions from each one of you.
Ashwati, you're muted.
My first question is that what are the two recommendations for government for making the ease of in patent and trademark IPR sector for the industry government should take? Means, is there any hurdles which are industry facing and government need to be amend that procedure to make it easy for them?
Akshat, I feel that the government should appoint more attorneys and registrars in the trademark agency to expedite the process so that people can protect their IP protection as soon as possible. There will be less disputes between the marks and the products, whatever they are using, and there will be an exponential, expedited procedure which can give an immediate result.
Okay, thank you, ma'am. Abhishek sir,
Yeah, Akshat, to answer your question, so I'll just throw light to what happened 2 years back. Now, if we see the examination of patents and also trademarks, that was quite fast, and we have seen an exponential growth in the grant of patents, which was more than 100,000. And even for examination of patents, that was about 75% more than the previous years. And now what has happened, there is a sharp dip in granting of applications, whether it's patents, trademarks, and also if we see the examination, that has also dipped a lot. Now, to address this for various stakeholders and also MNCs and other corporations, so we have approached the ministry and also the patents office, and we have requested them to engage more officers and to take steps where they can address this slow disposal, this slow examination by the patent office, which is actually adversely affecting the business of the stakeholders and the applicants. So now we have to wait and watch and see what the government will do and what steps they're taking to address the concerns. Maybe in a few months' time, we will be able to know about that.
okay, thank you, sir. Pulkit sir, any comment from your side on it?
Yeah, I'll just add to what Mr. Sen said. See, from the point of view of change in the legislature or the rules, I think in the past three years, actually since 2019, we have seen a lot of change that the procedures have undergone. I'm talking about the patent procedures. And with those changes, procedures have been simplified. A lot of burden on applicants has been reduced. There are processes, procedures for small entities, MSME startups, and individual inventors, educational institutes. There is a whole list of category of applicants who can claim benefit of expedited examination. There are certain category of entities who can claim benefit of reduced patent fee, the processing fee at the patent office. So in terms of the regulatory environment, the regulatory framework, I think we have seen a lot of change. Where I think that the government can focus on is probably training of the officers. At I'm not sure about the trademark registry, but I think at the patent office we are facing this issue of inconsistent application of laws and procedures. I think if there's more consistency, we will be able to invite and attract more, patent filings, not just domestically but also internationally. And I think ease of at least patenting, is going to go up, and I don't see any downside to that. So I think that's my feedback. Thanks.
Your comment, Miss Indu?
I would actually second whatever comments that my co-panelists have already put, because it is the delay that we are all facing in the examination stage and what all that stages. So I think registry has to attend to this query because a lot of applications are in a limbo, and registration becomes important to record ourselves in various e-commerce platforms and all that. So it becomes very more like a deciding factor to a lot of players in the market. So I would urge the registry to do something to expedite the entire process. And like Pulkit sir was saying, it is not for everybody to, afford the expedited route, because it's really huge. So, for the registry has to do something to also encourage the small players without paying more into it. Another point that I would want to suggest is, there has to be stricter checkpoints where the registry has to, check when examining an application, because a lot of times we see applications get published are really not. Distinctive. There are a lot of very very descriptive marks that get through, just cross through the examination and gets published. But a lot of times we see really deserving applications getting refused. So I think the registry has to somewhere keep a checkpoint where they really, strictly understand which mark has to go and which mark should not go.
Thank you very much to all our experts for sharing their insight and valuable knowledge with our participant and with us. And we will soon arrange a next session on this, because we are receiving too much queries on this. So industry want to listen from you more about it. So definitely we will arrange again. And thank you very much to all the participants to joining us and making this session more interactive by your queries. And we will answer all the questions to you, hopefully. And if anything is remaining, please mail us all your queries and speaker name. We will send to the concerned speaker, so that he or she will be able to answer you by email. Thank you very much. Thank you all the panel.